The next mistake that we see, number 6, is where if the person does hire a lawyer to pursue the claim, that person hides past accidents or hides past accidents from the insurance company, falsely tells the adjuster that the person had never been in an accident when that is in fact not true. Number 1, that really permanently damages your credibility, in which case, many adjusters will refuse to even make an offer or will make an extremely low offer because they just don't believe you now about how you were injured or how the injuries have affected your life. Mistake number 7 that we see is along the similar vein, where a person tries to hide their past medical history or medical conditions, either from their lawyer or from the insurance adjuster. Again, that's going to impact your credibility. For instance, if you've been in an accident where you've hurt your neck and a year earlier you injured your neck in another accident, almost always the insurance company is going to have knowledge of that prior accident, either because you made a claim for property damage or injury claim, and there's a vast database that insurance companies use, so they keep track of this information. So trying to hide past medical injuries or condition can really destroy your claim, and if you've got legal counsel, can make it virtually impossible for your lawyer to get the best possible result in your case. Mistake number 8 that we see is where the person makes statements to his or her doctors, damaging statements to their healthcare provider that show up in the medical records. For example, if you describe the accident as a fender bender, or that the person just bumped you and it was no big deal, when in fact it was a big deal, but you're just trying to remain stoic and for the benefit of the doctor, statements like that can hurt your claim. Again, the adjuster is going to be looking for anything in your medical records to minimize the extent of your injury. So if there are statements in the records where you're telling the doctor you're not hurt that bad, you feel fine when in fact you don't, or the accident was just a minor fender bender, those statements can drastically reduce the value of your claim. And if they show up in the records, as a lawyer, it's almost impossible for me to overcome those statements, not without sufficient work or not without much more treatment and expert opinions from other doctors to refute those statements. But even if I have that information, because they show up in the records, if the case were to ever go to trial, typically the defense attorney will blow up those records into a big poster so that the jury can see how you were describing the accident in such an insignificant way. And that can be very, very powerful evidence to a jury to award minimal compensation or award no compensation because they don't believe the accident was that bad or they don't believe your injuries were that severe. Mistake number 9 that we see is when the client really makes medical appointments but either fails to make those appointments or goes long periods of time without seeing a doctor, which we refer to gaps in treatment. If you are having symptoms from your accident, you should be regularly seeing the doctor. We get cases where somebody might treat for a few months and then stop treating for 6 months or longer, or even just a few months, and then pick back up again and resume treatment. When we have those gaps in care, again, the adjuster is going to latch onto that and wonder, well, he stopped treating and then didn't pick up again until 6 months later. How do we know he wasn't injured again? Or why would he stop treating unless he was feeling 100% better? So those types of things that we see can also be very big challenges in a case and be difficult to overcome when trying to settle the case for a reasonable value. Finally, number 10, clients or people, injured victims that either misrepresent how the accident has affected them or give false information. With today's technology, it's very easy for insurance companies to hire people for minimal expense to go out and surreptitiously tape record, video record people just going about their daily lives. And so I do see on occasion investigators show up in a case with video footage showing the person working at a tremendously challenging, physically challenging job, which seems to conflict with perhaps what the medicals are stating, or conflict with what the person is saying as far as how that accident affected their lives. You always have to be cautious that everything you do in public may be being observed by somebody from the insurance company or representing the insurance company's interests. It also can apply if you are, for instance, submitting applications to your own insurance company, either for disability benefits or health insurance benefits, where you make statements about your activity level that seem to contradict what your medical records state. I've seen, for instance, in one case, an application made for life insurance, where the application listed the person where he described his activity level as fairly robust, no problems, no serious medical problems, yet he had an ongoing personal injury claim where he was trying to claim that the accident had severely affected his work activities and recreational activities. So when the adjuster found out about that application, there was a significant problem there because there was a discrepancy, and I was unable to secure probably the result that I wanted to secure in that case because of that unrelated insurance application. So there you have it, 10 mistakes. Megan, I'm willing to answer questions if we have some.
Okay, great, we do. All right, so the first question I have here is, I was injured while on foot by someone riding a bike. What should I do? Is this at all like a car accident?
Yes and no. It's like a car accident in the sense that you have to prove that the bike rider was careless, was negligent in some way, and as a result of that negligence caused you injury. The difference, however, is with insurance. Obviously, most bike riders do not have their own bicycle insurance. However, I am finding that many homeowners' policies are covering bicycle-related injuries. So what I would do is certainly contact that person, the bike rider, and ask that person for his homeowner's insurance. Unfortunately, unless a lawsuit is filed, there's really no way to force that person to reveal that information, unless perhaps you take that person to small claims court or hire a lawyer on your own. So the short answer is yes, it is similar to other types of injury claims in the sense that you must establish negligence, but there might be differences when it comes to insurance coverage.